name is Namrata Pahwa. I'm an advocate at the Delhi High Court. I have my own practice specializing in intellectual property, media and entertainment law. Today we'll be talking about the importance of ADR techniques in the fashion world and fashion law in general. But before that, we have to understand what fashion law exactly is. So in India, there isn't an umbrella term or an umbrella act called a fashion law. It's an amalgamation of various things, like, of course, there's the intellectual property, there is trade law, which you have to think of, there is consumer culture. If you're a big organization, you have to think about labor laws, and of course, there's piracy and privacy issues. If I could take an example, it's like if an artist were to design something, everything from the thought or the concept of the design to when he or she sketches it on a piece of paper, to when it goes to a karigar, and then of course to a supplier, and then to the end consumer. So everything from the start to the end, and all laws required to streamline that particular aspect falls under the fashion law ambit. Now in India, as I told you, there isn't one umbrella act called the fashion law, but there are organizations trying to streamline it, like there's the FFI, FDCI and APEC. And of course, there are the Indian acts like the Trademark, Copyright, Design and Patent. We'll be discussing them in detail right now. So when it comes to intellectual property, before we begin understanding the various acts in detail, we have to first figure the way to go about it. So according to me, and this may come as a great tip for all budding lawyers that there are three main aspects of IP. First, which is prosecution, which means filing of all IP. Second is transactional, which means agreements or contract drafting. Fashion negotiation is a huge part of fashion law. And third, of course, is litigation, which is any sort of dispute resolution. Now let's discuss the different kinds of the acts that there are. First, and of course the most common, there is the trademark law. It's any graphical representation of, or a word or a sound recording or anything that would distinguish your brand from another. Something like a Chanel or a Gucci or an Armani that you can think of. It's the logo and the word mark. Preferably, you should file it separately. So each part of the mark should be filed separately and as a whole, so as to give a holistic protection to the mark. Now we come to copyright law, which is probably the most important facet of the fashion world. So any original literary, dramatic, musical work that any artist would create would be protected under the copyright law. In India, it isn't mandatory to protect it. As soon as you create it, you hold a copyright in it. But if you were to stop anybody else from using your copyright, you must have an application or a registration in it. Now let's go to patent law, the most technical form of the IP Act. It's any novel invention that you would think of would hold or would come under the patent law. So there are three requirements. One is that it should be novel. Second is that it should be able to be put to industrial application, and third is that it should have an inventive step. Now, of course, there are various standard essential patents available in the market. So if you want, you could play around with that, and then even if you add a certain aspect of that or a new inventive step to the standard essential patent, you can file a new patent as yours. So now let's talk about design law. Any 3D composition of lines, features or ornamentations when applied to an article can be protected under the design law. The most famous design example that I can think of is probably the Coca-Cola bottle, which has been amended through the years. But apart from that, there are various designs in the fashion law, like the Gucci bag or the Armani belt. Everything on the particular article can be applied and protected under design law. Now, like I said before, fashion negotiation plays a huge role. Now, when we talk about alternative dispute resolution techniques or ADR techniques, arbitration and mediation, how do you put that in your intellectual property? So the most important, or probably the most popular way of doing it, is through the clauses of a contract. Arbitration clause and how it's framed in a particular contract plays a huge role. Something like a license agreement or an assignment agreement or production house agreement. Every contract that you would see or draft must have a dispute resolution clause. Now, the reason why people choose to go through the ADR technique when it comes to IP is because of the confidentiality. Now, of course, suppose if you have a really important trade secret or a patent invention that you've created, you don't want it to be litigated in court where there are 25 people listening to every argument. So that is why an arbitration technique is used, so as to remedy the dispute out of court. When it comes to international intellectual property matters, arbitration is used in a way so that parallel litigation can be avoided. So suppose one party is in India, the other is in Hong Kong, and the arbitration is happening in Singapore. So how would you avoid parallel litigation is just by focusing the arbitration only and solely in Singapore and not in India and Hong Kong. So WIPO has actually done a lot to encourage arbitration in the intellectual property field. It has also started its own WIPO Arbitration and Mediation Center, where it holds and hears various cases all through the year. We'll actually be discussing a few right after this. So now let's discuss a few cases. Like we spoke about the WIPO Arbitration and Mediation Center, the first case that we'll be discussing was resolved at the WIPO Arbitration and Mediation Center, which was the FINDI versus Webmaster LLC. Now in this case, what happened was, of course, FINDI, as we all know, is a huge Italian brand and company. It has great goodwill and has amassed a lot of remuneration and love all through the world. It also has trademarked every part of its company, from its domain name to its word mark to its logo. Everything is protected. Now what happened was, a group of imposter websites which were registered under GoDaddy was using FendiWatches.com, and when Fendi got to know, of course, it wanted the particular trademark or the domain name to be transferred to them. Thankfully, WIPO agreed with Fendi because they were able to prove their goodwill, and they were able to prove that they have protection of their particular logos and word marks. That's how Fendi won the case against the imposter websites. Now let's talk about something more recent. In 2019, Federal Trade Commission sued TME LLC for its fraudulent claims that it was making. What happened was that TME LLC, without any scientific proof to back up their claims, claimed that if you would drink their teas and succulents and follow their detox plan, then it could help you from everything from weight loss to migraine. It also claimed that it could solve or cure cancer to some extent. Now, of course, there wasn't any research to back that up. So for an undisclosed amount that the two parties actually settled out of court, and the profits that TME actually generated, which was about 15.2 million that it made, it had to give something back to FTC. And in fact, FTC did a very smart thing. What they did was, TME, for their promotional aspect, it had garnered or got on board various celebrities and Instagram influencers. So FTC not only sued TME, it also sent legal notices to those Instagram influencers and celebrities. So this was a very important case for everybody to note on social media, that it's only once you know the research behind the claims, only then should you be able to back that up with your promotional aspects. Now for our last case, let's look at something from the Indian subcontinent. in 2016, Eros sued Telemax for an arbitration issue. What happened was that, as we all know, Eros is the country's largest producer and exhibitor of movies and commercials on various mediums. It also holds various licenses and copyrights. What it did was it went into a contract with Telemax. They had drafted or executed a term sheet and not a full drawn contract, where Telemax therein was allowed to distribute certain elements. Now, in that particular term sheet, there was an arbitration clause. Now, what the court held was that the matter was arbitrable because Eros was fighting it against Telemax only, which means the matter was arbitrable in personam and not in rem. That is why copyright issues in such cases can be solved through arbitration techniques and need not go through the litigation route. With that, we come to an end to the discussion. I hope this video was as insightful for you as it was fun for me. If you have any further questions, please feel free to get in touch with me. Thank you. Bye.